on title insurance. Laura Lowe is one of the underwriting counsel for Old Republic Title Company in San Francisco. She's been an attorney since 1982, and she's focused her practice over 25 years on title insurance and escrow. She's co-authored a chapter on escrow for the CEB treatise on real estate sales. She's also co-authored an article in 2010 for Miller and Starr, also related to escrow. She's co-authored a chapter on title insurance and navigation easements for the CEB treatise on easements and boundaries. And she's a member of the California Land Title Association, CLTA, Forms and Practices Committee and Education Committee. She's been a panelist for the CEB on numerous occasions, and also for the California Bar Association Real Property Section Annual Retreat and the ABA Title Insurance Litigation Section. She was a moderator for the 2012 Northern California CEB program on title insurance, so she knows her stuff. So I just want to welcome Laura, and go ahead.
Thank you very much. Thanks for being here, and I know that all of you are so thrilled about title insurance, and this has nothing to do with the MCLE deadlines approaching. We have such a large crowd. So how many of you work in title insurance all the time, with title insurance? So about half of you. What I'm going to try to do is focus on some issues that are more basic and do my best to get to the more complicated issues first. Now, I used to be a school teacher. I taught 7th grade. So what that means is I like questions, I like interaction. I don't want to be up here and just be a talking head for an hour, because that'll be pretty boring, right? So interrupt, ask questions, it'll make the class more interesting. I've given you a tremendous amount of documentation. I killed a lot of trees for this class. What we're going to start with, and we'll get through whatever we get through. We're going to start with preliminary reports. And why am I starting with preliminary reports? Anybody?
That's where you start.
It's the first thing that you get. This is the beginning for anybody who's handling a real estate transaction for a client or for their family or for themselves. You'll get a preliminary report. Now, most people take their preliminary reports and put them in their folders, put them away, never look at them, and then at the last minute before we close, they say, well, what's this and what's that? And they start flipping out about the exceptions that are in the preliminary report. So what I'm going to do is encourage you to read the preliminary reports. Now, a preliminary report is merely an offer to issue title insurance. It is not a document that you can rely on. What does that mean? And that's according to statute. Just so you know, it's Insurance Code 12340.11. Makes it clear that a preliminary report is not the status of title. It is not an abstract. It's merely an offer to issue insurance from the title company that you're working with. That offer can be pulled back, because a lot of times in a transaction, they get pulled back because of somebody like me, or an exception gets added because of somebody like me. What I do for the title company is I'm one of the underwriting attorneys. And the underwriting attorneys are the ones who make the decisions about what types of risk the company will take. The underwriting counsel, and sometimes the underwriters are not attorneys. Some of them are attorneys. Myself and Elliot Smith are the 2 attorneys for Old Republic. And I know the underwriters from all of the companies. What happens is we are the ones who get the weird things. We're the ones who get the calls from counsel saying, wait a minute, this transaction, you've got an exception here that should be removed. Then we look at that and we make the decision whether we can or cannot take that risk. Sometimes we can take a portion of the risk, sometimes we can't. What you want to know is when you're handling a transaction, You want to talk to the underwriter if you've got a complex transaction with difficult issues. You don't want to talk to your escrow officer about the issue. So you get the preliminary report, you are very diligent, and you read everything. The documents that are the exceptions are normally hyperlinked. Most of the companies for commercial transactions hyperlink the documents. That means you click on it and you can read the document. You read the document and you go, wait a minute, this doesn't apply anymore. This terminated in 1975. Why is it showing? If you ask the escrow officer, why is it showing? The escrow officer is going to call me. And they're going to say, why is this showing? The attorneys want it out. Or they're going to call the title officer. And the title officer is going to give them an answer, which is not your final answer. The final answer comes from somebody like me. Okay? So if you're getting an answer that isn't making sense to you, ask to speak to the underwriter. And keep asking to speak to the underwriter. Some underwriters are shy. As you can tell, I'm not. Most of the underwriters who work for title companies who are attorneys are not shy about talking to clients. Usually if you see somebody who is, it's somebody who is not an attorney and they get a little bit uncomfortable about interacting with you. But even the underwriters who aren't attorneys, most of them are very comfortable talking to counsel. So the first thing you want to notice, this is a marked up funny prelim that was done for educational purposes by one of our title officers. The first thing that you want to notice is that there's a property address there. I cannot tell you how many times we find out at the last minute that we've searched the wrong property because somebody wrote down 100 and it looked like 199 and we searched 199. So look at the property address. The name of the escrow officer is always on there and the phone number. Sometimes the name of the title officer appears on there. Okay? Now if you, and the front page tells you two important things. One, this is only an offer to issue insurance. And two, there's an arbitration clause in every policy. Okay? So let's flip to page 2, which is on the back. I tried to be economical with paper. The first line there tells you what type of policy the company is offering to issue. Very important. So I'm going to give you a real life example. I'm going to give you a couple of them that come from here. You'll notice that this preliminary report says a homeowner's policy. The CAR contract, the California Association of Realtors contract, says a homeowner's policy is to be issued on a transaction. So at 1 to 4 family dwelling, you expect a homeowner's policy. If the company can't give you a homeowner's policy, you want to say, why not? There's going to be a reason. That reason may mean that this property is inappropriate for your client or inappropriate for your mother or inappropriate for you. So you always want to see what kind of policy is being issued. If you're doing a commercial transaction, you're the attorney for your client's commercial shopping center, and instead of it saying an Alta extended owner's policy, it says an Alta standard policy or a CLTA policy, you want to understand why. What is going on that you can't get the expanded coverage? Sometimes the reason you can't get the expanded coverage is because there's a serious issue with that property. And we know there's a serious issue, and we're trying to tell you, hey, there's a serious issue about this property. You're not going to get the expanded coverage. Sometimes you will talk to the underwriter and they will say to you, we can give you some of the expanded coverage, but not all of it. And that's happening to me right now. I'm handling a large commercial transaction. We don't have a survey. Usually when you're getting an Alta owner's policy, we require a survey. The parties still want an Alta owner's extended coverage policy, and I've given you the jacket for that, so you can take a look at it. What happens is the Alta Owner's Extended Coverage Policy normally gives survey coverage. When somebody doesn't get a survey, you might be able to get an Alta Owner's Policy, and we'll put an exception in for survey matters. So what I'm trying to do with this client is I'm trying to narrow the exceptions so that there are exceptions that both of us can live with. And we're negotiating right now over which exceptions I need to leave in. They are fine with me leaving in the exception for survey matters. Where we're kind of going back and forth is a standard exception that relates to liens that are not currently of record. What kind of liens are we worried about? Mechanics liens. Those are the ones we're worried about. So for those of you who practice in the construction world, you will know, or in the title insurance world, that if there's work on a project before the transaction closes, and it's part of the entire project, there's a potential that somebody will file a mechanics lien down the road. So those are the kinds of issues that we're negotiating about right now. Are there any questions on type of policy that you're going to see there? Yes, go ahead.
So we have CLTA, you have ALTA, and you have this homeowner's policy. Can you just speak briefly of the difference between those three?
Sure. So what happens is there's two organizations that, trade organizations for title insurance. One is the California Land Title Association, and one is the American Land Title Association. Now, other states have their own title associations, but very few of them, except for Texas, very few of them produce their own documents, their own rules, their own policies, their own endorsements. Most of the time, CLTA and ALTA is what you're going to hear. The homeowner's policy was developed years ago in 1998, by First American Title. And they called it the Eagle. Okay, all of you might remember the eagle, because First American Title has an eagle as their symbol. So they called it the Eagle policy. The biggest difference, it was supposed to be a plain language policy for owners, and I've given you the covered title risks for the homeowner's policy. Eventually, all of the companies adopted it. It became the Alta or CLTA homeowner's policy. Those two are identical. If you get a First American homeowner's policy, an Old Republic homeowner's policy, a Stewart, a Fidelity, they're all going to be the same, okay? The biggest difference with the homeowner's policy is there are several differences. One big difference is it does give coverage for some encroachment issues, permit issues, survey issues, without having a survey. It's designed for a single-family dwelling. On some of those coverages, if not all of them, there's a deductible and a maximum. Typical deductible is $5,000, maximum is $25,000. The types of claims that we have handled on the homeowner's policy that would not have been covered under an old CLTA policy is the rebuilding of bathrooms. I have no idea why, but a lot of people do their bathrooms without permits. Somebody comes in from the permit department. I live in San Francisco, and these people are crazy from the permit department. Somebody comes in and they go, "Oh, can I use your bathroom?" They go into the bathroom, they notice something, and they go, "Whoa, the bathroom was done without permits." You have to, homeowner, open up the walls so that we can look and see if the plumbing was done correctly, see if the electrical was done correctly. A variety of things will happen because that bathroom was done without permits. The seller may have disclosed it to the buyer, in which case it would be something that title insurance wouldn't cover, the seller would cover it. It's something you knew about. But if the seller didn't do the work, but it might have been 10 sellers ago, then you might end up having coverage for that bathroom. And that is the most common covered title risk that you would not have on a standard coverage policy. Bathrooms, Encroaching fences is another one. Every fence encroaches because a property line is thinner than a board. So every fence encroaches to some degree, right? And very few people have agreeable neighbors where you get together and you agree to put up a fence and you each pay for 50% and you agree on the design and everything's lovely. I've never had that with my neighbor. Never. Even though that's the law in California. If it's a boundary fence, you each pay half. I've never had it happen. It's always a fight. So if that fence encroaches, the homeowner's policy provides coverage with a deductible and a maximum. It costs a little more, it's 10% extra. Okay? Those are some of the big differences. The one that's most relevant to you and your family has to do with trustees of a trust. So mom and pop take title. Mom and pop, after 5 years, decide they're going to transfer their property from mom and pop to mom and pop as trustee of a trust. Under the homeowner's policy, that's automatically still covered. The CLTA policy, it does not say that. So in order to make sure you're protected, there are a lot of people who just take the risk because they figure, well, it's a revocable trust, we can transfer it back, right? It may be revocable until mom dies, and then it's irrevocable. And then what happens if you have a title problem? You can get an endorsement called an additionally named insured endorsement, and that will bring the trustees of the trust in. So if you bought your property before 98, you probably have a CLTA policy that would not automatically give coverage to the trustees of the trust. If you bought a property after that, you likely have a homeowner's policy that does give that kind of automatic coverage because these mom and pop trusts are so common. Yes?
A lot of times people have to, the lender requires people to take the property in and out, or, out of the trust into the individual, but then after the refi goes, they put it back.
Yes.
So, and this can happen, every year, multiple times. Is that still covered if it goes back to the individual?
If it goes back and forth, no, it's no problem.
Okay.
And what happens is, let's say you have a CLTA policy, and you took it as mom and pop, and then you transferred into your trust, and you have a claim. And you submit the claim, and the title company says, the trustee of the trust is not an insured, and because of that, we're denying your claim. If it's a revocable trust, you can transfer it back. Most title companies, and I can't speak for all, and I don't handle claims. There are people in this audience who do, and so if I'm wrong, tell me. Most title companies are not requiring that you transfer it from mom and pop as trustees of the trust to mom and pop, just for the purposes of dealing with a claim. Am I right?
No. Well,
No? Okay, so some title companies are requiring it. Somebody said no. What has been your experience? Yeah, go ahead.
I have a client whose coverage was refused because it's been placed into a trust.
Yeah.
Flat out.
Flat out refused.
Yes.
Okay, all right. And you didn't have the option of transferring it back in?
It actually never occurred to me.
Okay.
I might try that.
Contact them and see if it'll make a difference.
One of the
Lee.
problems that
Yeah.
cause a rejection is if sometime during the course of the trust, some additional encumbrance, loss, whatever comes on, then you've got an issue about is there coverage for that, and that might prompt the denial of the coverage based upon the transfer.
Right. So if there's a problem because of the transfer, that's different.
That's really not the problem.
Yeah. But same thing, if you have a claim in title insurance, and again, there are a lot of people in here who deal with claims regularly. Most of the claims people are attorneys. It's probably 99% of them are attorneys, very experienced in title insurance. And so feel free to call them and talk to them about it. Most of the ones I know, almost 100% of the ones that I know, would be happy to talk to you. And, if you want to make a change like that and see if it makes a difference, give it a try. You have very little to lose. Yeah. Okay, so that's the type of policy. Now, the next big issue is the estate that we're willing to insure. This has caused more problems than you could possibly imagine because you are thinking that we are insuring a fee and an easement, and you don't see the easement there. Why isn't the easement there? What is the problem with the easement? Sometimes the problem with the easement is very simple. The easement is described as over the existing road. We have no idea where the existing road was in 1933, and because it doesn't have legal description, we may or may not be willing to insure it, okay? So you want to check that out. If you have anybody who's moving to Rossmore, nobody will insure those parking spaces. Why? Because the people have swapped parking spaces so frequently over the years since Rossmore came into existence that nobody knows who has what parking space. And nobody can insure those parking spaces. If I'm buying a condo in San Francisco, that parking space is going to be very significant, right? Especially if it's in a very dense neighborhood. So I want to see that I'm insured for that parking space, and I may get very uncomfortable and decide that that property is not for me if I'm not insured to that parking space. So parking spaces can be huge issues. Okay, the other reason in commercial property that parking spaces are huge issues, this is a real story that happened not long ago in San Jose. There was a commercial piece of property. They didn't have enough parking for the city. The city required them to acquire parking spaces somewhere else. Because they could not acquire parking spaces somewhere else, they could not use an entire floor of the building. They were not allowed to lease that floor of the building until they found parking spaces. So parking is a huge issue, commercial and residential. Any questions on that? Okay, what other states can you see besides a fee and easements? What other things are out there?
Mineral rights?
Mineral rights. Mineral rights are generally not insured specifically. If you're doing some sort of a solar project, the policy will look dramatically different than what I've got here, where you're trying to actually look at the mineral rights in a different way. Very rare for a title company to ensure that you have mineral rights.
You insure mortgages, you insure leasehold interest, ground leasehold interest.
Perfect. We insure mortgages, of course, deeds of trust. We insure leaseholds. Leaseholds, years ago there used to be a leasehold policy, doesn't exist anymore. The way leaseholds are insured now is there's an endorsement, the Alta 13, for a lender, the 13.1. It modifies the coverage of an Alta policy and makes the leasehold types of coverage, the relevant coverage, makes sense for a leasehold. Ground leases have been a huge problem. It is very common for especially low-income housing projects for the city to own the land because they want to control the project, have a severed improvement, and then the severed improvement is owned in fee by the lessee. So what you're going to see is a leasehold as to the dirt, accepting therefrom the buildings and improvements which are and shall remain real property. And then you'll have a fee interest in the buildings, the improvements, which are and shall remain real property. Whenever you're doing a severed improvement, get the documents to the underwriter early. We have had attorneys who have done these incorrectly, and it holds up the transaction. They're not as common outside of the low-income housing world, but they are happening enough that if it comes up to you, just get a sample from the title company. How should we set up the memo of lease? How should we set up the deed? Or here's my sample, does that work for you? Okay? Yes?
What about tenancy in common?
Tenancy in common. Tenancy in common, very, very common. So it happens in commercial world, right? It happens in the commercial world all the time. Tara and I buy a piece of property together. It's an apartment building. I own 20%, she owns 80%. So we've got 100% ownership, but it's split 20-80. Those are insured. What happens in San Francisco, as you probably know, because of the housing crisis, people are setting up tenancies in common for residential units that really look more like a condominium, but they haven't been approved by the city because they're crazy. That's all. I mean, I live there, I can say it. The people are just nuts because they think somehow that's going to help the issue with high rents. It doesn't make sense to me. So what happens is you have a 4-unit place. The parties enter into a TIC agreement on how things are going to be operated. Each person has exclusive occupancy of a unit. Their percentage interest is usually based on the square feet of their unit. Everybody normally gets one loan together. So you can already see the problems when you're selling one interest, one unit. What happens with the loan? How does the person pay for it if it's appreciated? What happens when one of the owners dies and their estate hasn't been set up yet? Who is making their portion of the mortgage payment? Many issues. There are 1 or 2 lenders that will lend on individual units, but it's not very common. Usually it's a loan for the whole building. Okay, so those are the types of estates that we normally see. Sometimes the most important thing for your client will be, as I said, the easements. Light and air easements are very common in densely built areas, particularly for commercial buildings. You don't want your window looking right out onto another building because the amount you're going to be able to charge for rent goes down dramatically. So you want to make sure that that light and air easement is being insured. That's just one example. Yeah?
So I want to make sure I
Yes.
understand this. So you have an appurtenant easement runs
Yes.
with the land. The bottom line is if you have a challenge to that appurtenant easement, even though you have the fee insured, you will not have coverage unless it's called out as a separate estate to be insured?
Absolutely, absolutely. So unless it involves an access issue, because the policies give coverage for access. So if it's not an access easement, you want that easement insured. Now, let's take a light and air easement. Yeah, go ahead, you have a
I'm sorry,
follow-up question.
Well, yeah,
Yeah.
just one permutation on that,
Yeah.
because I just had to deal with this. If you provide for coverage of the easement, you call it out. The
Yeah.
fact that the deed does not separately call out the appurtenant easement, you're still providing coverage as long as it's stated as such in the document, correct?
If it's a covered estate,
Yes.
normally, and the reason I'm saying normally is for years before I went into underwriting, I worked in claims, and what I can tell you is there are so many permutations on how a claim comes in. So I can't tell you 100% without looking at the actual issue, but normally when we have insured an estate, that estate is insured. Now sometimes the easement is dropped off of the deed. If it's an appurtenant easement, it still runs with the land, it still exists. But let's say somebody challenges that easement. It's a common title insurance claim that there's an easement problem and somebody is challenging that easement. Sometimes it's an easement for your electric lines to come into your building. Sometimes it's an easement for parking. Sometimes it's an easement for light and air. But those are commonly covered title insurance claims where an easement is insured and there's a problem with that easement. If it's an appurtenant easement, it should run with the land whether it's on the deed or not. Am I correct, real estate people? Yes. So it shouldn't be relevant. Normally, if a title company is insuring an easement, it automatically goes on the deed because the title company is often preparing the legal description for the deed. We get instructions all the time that just says, take the legal from your prelim and tack it on to our deed and deed of trust. So normally it should be there, but sometimes a page drops off or there's a computer glitch and it doesn't show up. Okay? Yes, question.
In order to ensure that easement, does there have to be specific language in the policy addressing that, or is it just included in the general insurance provision?
There are, It's included, it's under the general insuring provision. But what you're looking for is when there's an estate that's described, you want to see that easement described. So parcel 1 is the fee, parcel 2 is the easement. You could have 10 easements on these energy deals, these solar projects. I don't know if any of you have worked on them. The easements are critical because you have to be able to connect the energy that you're generating to the station that is converting that to electricity that is being sold to PG&E. If you don't have those easements, you can't get the electricity to PG&E, and you've got all these windmills running around, or all these, solar panels that aren't doing you any good. So easements are often critical to the value of your project. Make sure those easements that you need are being insured. Yes, question.
I kind of have a follow-up question.
Sure.
What if you have a description, the easement is in the title policy, but it didn't somehow make it into the grantees?
Yes.
You just want to do a correction.
Yes.
Does title cover?
So correctory deeds.
Sorry.
Yeah, no, that's fine. That's no problem. Who is responsible if you need a correctory deed? The question of who is responsible is not an easy one to answer. And the reason is it depends on who drafted the deed. So a lot of times the attorneys draft the deeds and they hand them to us and they say, please record this deed. And there's a mistake in the deed. Sometimes it's a covered title risk, sometimes it isn't. Sometimes it's something that the attorney created. A typical one that is covered that happens with great frequency where you need a corrective deed is when you have a condominium complex. They're selling out the units. And the person at the very end who is tacking the numbers on the door goes from left to right instead of right to left. And every condo in that complex, everybody's living in the wrong unit. So, you thought you were buying unit 3B, and instead you ended up with unit 10B. That's a very common issue where everybody gets together, because as you can imagine, every title company has probably insured that development. So everybody gets together and they swap deeds. The deeds of trust all have to be corrected. And it's a mess to unravel, but that's a common covered title risk that is insured that happens with some frequency on new condominiums. Okay? So, yes, question or
Going back to
comment?
the issue of easement on what I call the homeowners 1 to 4, does assure access. Now, it may not be the easement you think you have based upon what the deed might say, but if you're cut off from access, that at least raises the potential for a claim.
Right. Access claims, on most policies, you will find coverage for access. Sometimes the title company will carve it out and they will say, this property does not have access, it's landlocked. So your client has to decide, is that appropriate property for me? Sometimes it's perfect property for them because they bought the one next door and they're going to create an access over the next door property. This comes up most frequently with farm property, with like the vineyards in Napa. I've worked on some where there have been access issues, but they're buying the piece next door, so it's not a problem. Yes, Tom, question.
Yeah, it's something I just lived through a little nightmare of.
Yes.
If you're going to get insurance on an easement, you need to make sure the title company has run a search of all encumbrances on the servient tenement.
Yes.
Because if there is a mortgage or deed of trust on the servient tenement and your easement is junior to that deed of trust, a foreclosure will wipe out your easement. And so it's really critical, and you'll then have to deal with the title company on whether or not you can insure around the mortgage or deed of trust. But it's only the beginning of your inquiry. If you see an easement, you need to make sure that easement will survive on the serving tenement.
Right. Right now, the economy is going on the upward direction, right? we were going way up, and nobody thought about the foreclosure issue that has been mentioned. If your client needs that easement or needs that license or whatever it is, it could be something as simple as an easement for a sign advertising their business. If they need it, the lender has to agree if it's coming in after the loan, because all of those foreclosures created a nightmare for people on their easements. And these are easements that people paid for, negotiate with your neighbor for an easement, pay them, $50,000 for that parking easement, and then it's gone. And what are you going to do? You can't really go after the person you negotiated with. They gave you what they had. And they're broke. They've lost their property to foreclosure. So there's no money to go after. So make sure if you're doing a transaction for yourself or for a client that you take care of it. Now, the vesting issue, my boss was telling me yesterday that he gave a class like this, and they spent the entire hour on vesting. Nobody expected it, but they spent the entire hour on vesting. We're not going to do that. What I'm going to tell you about vesting, so here's what you need to think about. Look at the vesting if you're representing the seller or the buyer. Does it match what you think it should match? Is there any mention of bankruptcy, a receivership, a probate? Does it say subject to exception number 10? And then you have to look at exception number 10. What is going on with the vesting? Now let's assume, like in this sample, there's a mention of bankruptcy or a receivership. What you want to do is get the information early from the title company to find out what is needed to transfer this property. I have one transaction I'm working on now. It has been dragging on for months because they're waiting for a settlement. I have another one where they come into us and they give us a court order. The court order is meaningless for transferring title. So you've got to make sure that it's taken care of appropriately. Someone's in a conservatorship. Somebody has died. How is that transaction going to happen if one of the buyers or one of the sellers died? Is there a probate? If there is a probate, then great. But a lot of times somebody dies, their children are selling the property, and they haven't started the probate yet because they go, hey, I'm the only heir, I own this property. Well, the transaction's ready to close, and we go, where's the probate order? It's a serious problem, and it happens over and over and over and over again on both commercial and residential property. It delays things forever. So you want to make sure you get a draft of the order to the title insurance company so we can say, yes, this one will work, or no, you need to add something. I looked at a court order yesterday. It doesn't work. They're going to have to go back to court because what did they forget to put on the court order? The property's legal description. So if there's no legal description, the recorder won't record that. There's no reference to anything that tells us what the property is. You have to have the legal description or a reference to a recorded document. Best to have both. Okay? So that's the vesting that I'm going to cover. Are there any vesting questions before we move on? Any questions about same-sex marriage in this group? Okay. Same-sex marriage, just the same as regular marriage. Community property with right of survivorship. There's no difference, okay? So that's the big news about same-sex marriage. Now, when you're going through your preliminary report and you're looking at the exceptions, if it's a commercial transaction, you're going to want to start to think, what endorsements do I want for my clients? So an endorsement adds coverage or takes away coverage, right? We can do either thing. It modifies the policy. Now, there are many, many endorsements. In California, title companies have the option of creating a special endorsement for your transaction. In other states, that's not true. So I was talking to our underwriter in Oregon yesterday, and he had a problem. We in California could have just created an endorsement to deal with the issue. In Oregon, they're not allowed to do that. In Texas, they're not allowed to do that. But in California, you're allowed to do that. In Hawaii, you're allowed to do that. And I think in Arizona, you're allowed to modify with endorsements. A simple word on creditors' rights. People used to get something called a creditors' rights endorsement that gave coverage for certain bankruptcy issues. That is no longer available. It's no longer available for a bunch of reasons. One is some large case law, some large cases that hit title companies very heavily. One, that was horrible. And these types of cases caused enough of a loss for title companies that the state of Texas, because they think they're so special, they came out with a law that said if a title company offers creditors' rights coverage beyond what is just in the jacket of the policy, anywhere in the country, that they will not be allowed to issue any policies in Texas. So all of the companies issue policies in Texas, and so you're not going to see, no matter how much you say, I need that creditors' rights coverage, I want that, I got it all the time before, you're not going to be able to get it, okay? Because anybody who gives it, it really is running the risk of not being able to issue policies in Texas. The reason Texas gave for this is the idea that the losses on creditors' rights were large enough that they were concerned about viability of the company to handle normal title insurance claims.
Laura,
Yes, question.
is there a conveniently available list of available endorsements for both owners and lenders?
Absolutely. The question, in case you didn't hear it, is there a list of endorsements available? Yes, there are many lists of endorsements available. One place that I know of is, it's in the Miller Star book, isn't it? Anybody here? Who knows? I believe it's in the Miller Star book. CEB book on title insurance. I'm working on the update on that. It has all of the endorsements in it. If you go on the internet and you just type in Alta endorsements, you will get a list of all of the American Land Title Association endorsements. Every company has it on some website. So, there's a website that Stewart Title maintains. It's on that it's on every website you can think of. Okay? So if you don't have any of those books available, it'll be on the website.
I have a binder for years, and I'm trying to remember who publishes it. I think they still keep it up. It literally has all the endorsements.
So this gentleman has a binder, and the binder probably came from CLTA.
Yeah, I think it was CLTA.
Okay, California Land Title Association put together a binder years ago. It's now a computer program, and I believe that you can purchase the policy and endorsement computer program from CLTA for a fee, and that will be up to date. It'll give you the language. You can copy and paste it so you can play with the words and make some changes so it's specific to your transaction. The best part about it is that one is up to date. That's 100% up to date, and it's not expensive. I don't know what it costs, but it's not expensive. And it comes, as I recall, on a CD. Easy to search, easy to work with. Okay? There will be differences in numbers on endorsements. So there's Alta numbers and there's CLTA numbers. If you get the CLTA version of the policy and endorsement manual, those numbers are in a chart that you can look at. It's right there. Also, if you put that on the internet, most companies will have some sort of a chart that will track that an Alta 32 is a CLTA 137 or whatever it is, okay? Because if you use the word CLTA whatever in Arizona, they're going to say, what? I have no idea what you're talking about. If you're going out of state, you always want to use the Alta numbers, so you look like you know what you're doing, right? You also, if you have an old book that's out of date, you don't want to ask for an endorsement, and then what you get is dramatically different than what it used to look like. The endorsements have been really dramatically overhauled in the last few years. I don't know how many of you have looked at them. The comprehensive endorsement is the most common endorsement that's asked for in a commercial transaction. The comprehensive endorsement for lenders and owners has been dramatically modified because of two things. One has to do with the case, and I think it's called, is it Allstate versus, it's one of the insurance companies, Nationwide, maybe it's Nationwide. Lender forecloses. Lender goes to sell the property, and the lender discovers that somebody has the right to approve the owner, the new buyer on that property. They have the right to approve that buyer under a CC&R. The CC&R was accepted from the policy. The old Alta 9, which is the 100.2, had been given to the lender. There is coverage in that policy, in that old endorsement. There was coverage for somebody else having a right to screen out the new owners. So what happened was you have an exception and you have the endorsement. And the question was, doesn't the exception pull that coverage out of the endorsement? One court said no. Unless the exception specifically said that the CC&R had a provision that the beneficiary of that CC&R had to approve the next owner, then that court said there would be coverage under that endorsement even though you had this kind of generic exception. So what happened is Alta amended all of the comprehensive endorsements, and that type of coverage is given under a different endorsement called the 9.6. The 9.6 is called the private rights endorsement, and it gives you coverage for some of those kinds of issues. If somebody has an option, if somebody has the right of first refusal, those types of issues are covered. When you want that coverage, you want to ask for the 9.6. Another dramatic change in endorsements is they've added something that in the Forms and Practices Committee we call the Fracking Clause. Because of fracking, all kinds of things are happening to properties across the country. So what happens is properties are moving, properties are having all kinds of issues, and sometimes people have put claims together against title companies for issues on their property that are connected somehow with fracking. I have no idea how. So there's now a fracking clause that says the endorsement doesn't cover for those types of issues, fracking issues. The closest thing I can think of here is, when you have a major earthquake and properties move, or you have a slide. There are areas in Berkeley where properties have slid and now there are encroachments. That's not a title insurance kind of issue. That's more of a homeowner's policy issue. So this addition to the endorsement makes that clear. The other big change in endorsements has to do with something that the CLTA called the 103.1 endorsement. The 103.1 endorsement in the old days was an endorsement you could rarely get, and it was designed for an easement that no longer exists. For example, you have those old water rights easements from the early 1900s. The title company confirms that, in fact, everybody's on public water and a different easement has been set up. So you would get something called the 103.1 for those unlocated dead easements. Or if there was a blanket easement over your property, and in fact PG&E put the line along the west edge of the property and it's a PG&E easement, you might have gotten the 103.1 for everything except the west edge, and for the west edge you would get a different endorsement. The 103.1 doesn't look at all like it used to look like. It now gives coverage for damage to a building because of an easement problem, because of the right of maintaining an easement, or because of an encroachment onto an easement. Totally different endorsement. Why they gave it the same number as this old endorsement, I have no idea. The old endorsement just doesn't exist anymore. So you want to make sure that if you ask for a 103.1, which is on everybody's standard list, that you know what you're getting. You're not getting the old 103.1, you're getting the new one. If you ask for an Alta 9 or a 9.2 for an owner's, what you're getting is the new version, not the old version. Okay? You always want to keep up with your endorsements so you know what your client's getting. Another change, big change that's come up has to do with mechanics liens. Now, I bet you can guess why there's a big change on mechanics liens. Anybody? There's more limited coverage, much more limited coverage on mechanics liens, because during the downturn, title companies had enormous mechanics lien claims. Every law firm that we worked with during that time period, a lot of what they were handling was mechanics lien claims. Because when the economy went down, people were unable to sell their property in a subdivision. The way it used to be is the lender would come to us and they say, okay, they've already started the project. We want mechanics lien coverage. We would look at the financial condition of a large developer. We would take their indemnity and go. Well, the problem is some of those companies, I think there was a company in Sonoma, I think it was called American Homes. They were huge. They had been around forever. They no longer exist. There were companies all over the state that were large developers that no longer exist or went into bankruptcy and kind of limped along for a number of years but could not stand behind that indemnity. So the title industry came up with a different approach for mechanics liens. It's called the Alta 32 endorsement and the Alta 33 endorsement. So the coverage for mechanics liens, all of you have an Alta loan policy, and you'll see that mechanics lien coverage is under 11A of the policy. The Alta 32 removes that coverage and replaces it with coverage that is basically on a look backwards basis. That's the easiest way to describe it. So normal mechanics lien coverage, it's mechanics liens in general. So mechanics lien hits for work that was done on day 5. Mechanics lien hits, they name the lender. Normally there would be coverage for that. If they're saying they're superior to the lender, normally there would be coverage for that. Obligatory advance, the lender is paying for the construction. Normal circumstance, there's coverage. Now, what happens is under the 33 endorsement, the title company is reviewing the same package that the lender gets. We want to know, so we can analyze our risk, what has happened on that project to the date of the policy, and we give coverage going from the date of the policy backwards for any money that's paid for out of the construction loan. So somebody breaks priority. This is relevant when there's broken priority. Do you guys know what broken priority is? Nope. Okay, so broken priority, just a simple concept. If a worker starts on a project and after they have started, lender records a deed of trust. The last person who does work on that project, if they don't get paid, they often have priority over that deed of trust. And I say often because there's a million exceptions. So when work starts on a $100 million building, before the deed of trust goes of record, and the cost of construction is $70 million, there is a potential that $70 million will be ahead of that loan. High risk, right? So what we do now, since we had a lot of claims on mechanics liens, is before close, we get a package. What work has been done and what do we have proof of payment for? So we get lien releases, canceled checks, invoices, something that shows us that zero is owed at the moment of close. And we are giving coverage on a look-backward basis for the money that the construction lender is basically reimbursing the owner for that work that's been done. So it's money that the lender pays for work that's been done before the date of the policy. Now, lender's ready to give their next draw. A month down the line, they're going to give out another $10,000. So the coverage, remember, is on a look-backwards basis, and it's dated as of the date of the policy. Lender wants coverage for this interim period, that 1 month period. The 33 endorsement moves the date of coverage from the 32 endorsement, from the date of policy, to the date of the 33 endorsement. Again, what do we look at? The same package the lender looks at. What has been done, and has it all been paid for? And that's how we march forward instead of the old 122 endorsements. Now, this is when we have a loss of priority. Sometimes attorneys get very creative, and I'm working on one in another state right now, and the way they got creative is they got subordinations from all of the contractors, the subcontractors, the material men for this project. They know who's working on it. They got subordinations. We are giving a hybrid kind of coverage only for those subordinated workers. Okay? So you can get creative around mechanics lien coverage. Most title companies are using the 3233. I went to a class, or I saw a class that was given by First American. They told us in that class that everybody is using the 3233 when there's a loss of priority. And I received a call from a lender. They had gone to every title company trying to get blanket coverage, and everybody said no. They asked us, we said no, you get the 3233. Okay, so let me check our time here. We just have a few minutes left before we hit our hour. So let me quickly tell you what I've given you and give you some resources. What you have is the covered title risks under a homeowner's policy. So you can read that at your leisure. If anybody's buying a piece of property, they might want a homeowner's policy, right? Because it gives more coverage. If somebody, and just so you know who's asking for these types of coverage, somebody buys a $40 million single-family house down in Los Angeles, they're asking for the homeowner's policy. They don't have to get a survey, and they're getting some kinds of survey coverage. It's a single-family dwelling being bought by usually some kind of person on behalf of a movie star or a director or somebody who's famous. And that policy is the preferred policy even for large homes. Okay, you have the policy jacket for an Alta owner's policy, the current version. And that's the one that is usually given with a survey. If you don't have a survey, it's called an Alta standard. The standard exceptions are in there. You'll see them. They're B1. I've also given you all of the conditions and exclusions for the Alta owner's policy. I didn't print them for all of the policies, but I did for the Alta owners, so you can really take a look at it. The most typical exclusion that comes in is something that happens after the date of policy, or something that is known to the insured. Created, suffered, assumed, or agreed to by the insured. Those are the most common exclusions. The next thing that I've given you is, let's see, so you've got the prelim, the Alta owners, the jacket for the Alta lenders. I didn't give you the conditions for that in the interest of saving paper, but you can again find those if you get that CLTA P&E manual, policy and endorsement manual. If you look in the Miller Star book, I think they probably have a copy in there. CB, you can find copies very easily if you go on the internet. So that's the information that I've given you. Are there any more questions? Okay, thank you very much.